Investment watchouts for startups. Hi people, would you be interested in understanding about investment watchouts? I know you are. Let's talk about making some cash. Investment watchouts is quite simple. It's like art of getting investment is to bring in maximum amount of capital while giving up minimum amount of control and financial benefits. Remember, you're the owner. It is important and fun to talk about the investment, but let's talk about some of your questions here that you must have in your mind. Some of the questions can be, why do you need the capital or investment? Can you afford to delay and avoid investment? Or maybe what will the investment bring with it? It can be opportunities, investor control, investors' share in the profit or risk, intellectual property, and connections. But there are options as well, such as raising capital by yourself or others, reinvestment of profits, and loans or borrowing. Would you like me to keep going with the questions? I know I should because these questions are creating an understanding. Now, if you get the investment, the next question is, how much control do you want to keep? Less than 50%? 50%? More than 50%? Or 100%? Another important question is the need for investment more than the need for control? There is also a question of what type of investment do you want? Cash, movable or immovable, property, shares, sweat, equity, services, expertise, know-how. Getting investment becomes possible, but what kind of investor do you want? Active or passive? Aren't we all a little concerned about the control? We always talk about it. How about while we start answering your questions, we can talk about your understanding of the term investment watchouts. Now I need your attention. The first is private limited companies, which are the preferred business vehicle for investment. The other being limited liability partnerships and general partnership firms. Second, private limited companies are the practical, advisable, and preferred option for foreign direct investments. Third will be private limited companies that cannot buy back their own shares. Only public listed companies can do so. This may change in the near future, by the way. Fourth is foreign investors should only invest in companies. Sixth, foreign investors should not become partners in general partnership firms. There are many reasons for this, one being that companies are more tightly regulated under the company's law as compared to general partnerships. And seventh will be shareholders, who cannot be removed forcibly from companies under the law, but directors can be. Let's talk about the documentations you are going to need in the process of investment. Some of the basic documents are letter of intent or expression of interest, term sheet or memorandum of understanding, shareholders agreement or founders agreement, share purchase agreement or share transfer deed. But there are also some of the business entity constitution documents, which includes company, articles of association, LLP or LLP agreement, partnership firm, partnership deed. Don't worry, you don't have to memorize them. A lawyer can take care of these. But it is always better not to look at your mobile when the legal talk is happening. Remember when we talked about the basic documentation? There was a document about the shareholder. It consists of shareholding structure, kinds of shares and rights attached to shares, ordinary voting shares, shared risk and benefits and control, ordinary non-voting shares, shared risk and benefits, preference or preferred voting shares, more secure with fixed, Preference or preferred voting shares, more secure with fixed return and voting rights. Preference or preferred non-voting shares, more secure with fixed return but no voting rights. Authorized capital or paid-up capital, all issued shares must be fully paid up. Share subscription money for newly issued or allotted shares must be deposited in the company's bank account by the subscriber within 30 days of issuance, and the same should be certified by a chartered accountant and reported to the SECP within 45 days of issuance. Non-cash share consideration is subject to valuation in accordance with the law. Evidence and legal compliance for the above. Conditions for issuance of shares against services. Post-incorporation only. Shares cannot be issued against services at the time of company incorporation. Valuation of services by 2 independent chartered accountant firms having satisfactory quality control review awarded by the Institute of Chartered Accountants of Pakistan. In case of difference in valuation, shares shall be allotted on basis of lower valuation. You can also use the option of giving shares to someone who is not from Pakistan. The term is shares to non-residents. It requires shares to non-residents, that is, persons resident outside Pakistan, must be registered with the State Bank of Pakistan (SBP) for repatriation of dividends, disinvestment within 30 days of issuance. Let's talk about the factor of control in the investment watchouts. It includes 1. Shareholders, who can elect directors and appoint external auditors. Board of directors, they can appoint chief executive, they can appoint company secretary, they can appoint legal advisors and appoint committees. Chief executive, he can appoint employees. Shareholders. Quorum, ordinary resolutions, 51%, that is simple majority. They can make special resolutions, 75%, 3/4 majority, and they are not answerable to anyone within the company. Board of directors, their responsibilities are composition, quorum, passing of resolutions, and they are answerable to shareholders. Examples of quorum for a board meeting. Any 2 directors together representing not less than 51% of the voting shares in the company. Any 3 directors with at least 1 director representing shareholder A and 1 director representing shareholder B. Control. Chief executive. Chief executive is the CEO of a company or the managing partner in a partnership firm or LLP. He or she is answerable to the board of directors of the company or partners in a partnership firm or LLP. The chief executive can legally bind the company or partnership firm or the LLP and can also appoint employees. Watchouts. Powers of general meeting, board of directors and CEO. Voting rights. Decision-making thresholds. Dilution and anti-dilution. Dispute resolution. Share transfer or issuance restrictions, board approval, pro rata share offering and right of first refusal. Watchouts, tag-along rights and drag-along rights, veto rights, convertible notes or debts, vesting and reverse vesting, stock options, data protection, non-competition, non-solicitation and conflict of interest. Post-termination obligations. Watchouts. How will disputes and deadlocks be resolved? Any mechanism for internal resolution? Governing law and jurisdiction. Which law will apply? Which courts will have jurisdiction in the event of disputes? Dispute resolution. Litigation. Negotiation. Mediation and arbitration. After all the watchout, it is important to talk about changes proposed in the law. The Companies Amendment Ordinance 2020, currently lapsed, brought about the following changes in the law for startup companies. They can issue sweat equity and assess value of sweat equity themselves, currently only allowed if certified by 2 independent chartered accountant firms and approved by the SECP. No need to deposit cash against shares within 30 days as currently required. Can issue employee stock options, currently only permitted to public companies. Can buy back their own shares, currently only permitted to public listed companies. It is important to look at the revenue sharing versus joint venture. Salient features of revenue sharing model are: the 2 collaborating parties remain independent and enter into a contract to work together for a business. The parties contractually define their roles and responsibilities and agree upon a revenue percentage. The service provider is usually compensated for the development of the product, generally in 3 or more phases: advance, completion of 1 or more milestones, and final payment. Ownership of IPRs vests with one party, usually the party who pays for the services, while the other party who owns a limited license. Salient features of joint venture model. The parties form a special purpose vehicle specifically to execute the task arising from the collaboration. The roles and responsibilities are contractually defined and are also spelled out in the SPV's constitutional documents. The developer may be compensated initially in the form of money or shares. The parties co-own the SPV. The SPV owns the intellectual property rights in the product. The revenue is received on the bank account of the SPV and is split in accordance with the constitutional documents and the law.